Ryan, are you good if we get started?
Yeah, I'm great.
I want to thank everybody for joining us today for today's webinar about open records. Ryan Austin with Farrar Bates will be presenting today. He joined the practice in 2019, and in his practice area, he focuses on municipal law, employment discrimination and retaliation, general tort liability, municipal liability, and trial and appellate litigation. He has a strong understanding of cases involving the Fair Labor Standards Act, FMLA, discrimination, and whistleblower claims. He's a Nashville native and he enjoys traveling the world with his family in tow and likes skiing, hiking, and biking. And we're excited today for him to present open records. So I'll go ahead and turn it over to you, Ryan.
Thank you very much. I want to thank everybody for joining today on this lovely Wednesday afternoon. Depending on where you are, it's a little gloomy here, but hopefully we can make it through this presentation. So we are dealing with Public Records 101. This is not necessarily your Masters in Public Records Act. Instead, this is more of a basic understanding. And so we're going to go through and kind of hit the basic overview of the Public Records Act. And so there may be some questions at some point in time, and you're welcome to go through and to place those in the chat, and we'll try and answer those as best we can during the applicable time period. So feel free to send those in. We can try and answer those if there's a good time to go through and answer them. And so we'll go through and get started. The Public Records Act, that is a statute that was enacted in 1957, so it's been around for a little bit. And you can find it at Tennessee Code Annotated 10-7-501. And there are several provisions in there. And I'll be honest, it can be a little complicated just going through and looking at it on its face. So there's a lot of information in there. There's a lot of different aspects. And so we're going to try and hit, like I said, some of the high points to go through and explain exactly what it's all about. But at its core, the Tennessee Public Records Act goes through and provides that all state, county, and municipal records are required at times to go through and to, let's pull up the slide here. All state, county, and municipal records shall at all times during business hours be open for personal inspection by any citizen of Tennessee, and those in charge of such records shall not refuse such right of inspection to any citizen unless otherwise provided by state law. So as an attorney, one of the things I generally look at is, I'm going to go through and kind of figure out, all right, what's required under the statute. And one of the first things here that points out to me is that it applies to citizens of Tennessee. So one of the things you'll go through and look at there is that, somebody from outside Tennessee, a citizen from elsewhere, is not necessarily going to have the same abilities and rights under the statute that a citizen of Tennessee will have. So it also kind of parsing that out a little bit, it goes through and provides for all state, county, municipal records. So it's a pretty broad provision providing for those broad public records. And so those are, again, required for personal inspection during business hours. Can't go through and do it during late night after some sort of, say, a municipal meeting or anything like that. It's supposed to be during business hours. So typically 9 to 5. Can't be required to come in on Christmas Day to go through and search some records. So obviously that's put there in the statute to make it go through and to be reasonable. And the policy behind that is to go through and to allow citizens to access those records and to make sure that there is governmental accountability. So you've got to go through and to make sure that there's transparency to enable the citizens to understand, what's really going on behind the government and, what's going on, because obviously the citizens are taxpayers, they go through and they fund the government. So that's a little bit about the policy behind it and why it was enacted. And so the general general rule is that generally these records are going to be available. So now there are a number of exceptions, but Tennessee courts have gone through and found, even in the face of serious countervailing considerations, unless there's an express exemption within the law, then the record's got to be released. So that's something that's going to go through and kind of serve as our baseline understanding that generally these records are going to be permitted to be inspected. So what exactly is a public record? So in the statute itself, a public record Means all documents, papers, letters, maps, books, photographs, microfilms, electronic data processing files, output, films, sound recordings, and other materials, regardless of the physical form or characteristics, that were made or received pursuant to law or ordinance or in connection with the transaction of official business by a governmental agency. So that's pretty broad encompassing, going through and identifying exactly what a public record is under this act. So generally, when you think about a public record, you're going to think it in the most general sense about a document, a paper document, but that the statute goes through and it expands beyond that. So it's not necessarily just documents and papers. You know, it is letters, it is maps, photographs, recordings. So you may be dealing with video or sound recordings that somebody may go through and request. And so, again, some of the limitations there may be whenever you've got these documents that are made or received pursuant to law or some sort of ordinance that the city or county may have, or in connection with the transaction of official business by any governmental agency. So again, it's pretty broad to go through and to have opened up to have these records to go through and have inspected there. So when you're looking at the scope of this, you're looking to see, all right, were these documents that are being requested, were they transacted with some sort of official governmental business in mind? You know, if you've got somebody that comes in and requests certain emails between two employees, say the two employees have gone through and emailed about, okay, where are we going to lunch today? That's obviously not necessarily going to be any official business by any governmental agency. But if you've got somebody that comes and says, hey, I want receipts from a certain time frame from the city that they went through and spent on a certain project, that's obviously going to be more in connection with the transaction of official governmental business there. So one other thing to kind of point out here that's on the slide. So public record or records does not necessarily include the inspection of the device or the equipment that the document may be on. So just because someone goes through and requests maybe text messages or emails about a certain subject, the citizen's not necessarily enabled or permitted to go through and to inspect the device itself. So the citizen's not going to come in and look at the individual's computer, which the document may be stored. Instead, it's going to go through and likely be printed out or stored in some flash drive or some other capacity there. So that's one thing to think about. So, you know, one thing in terms of a lot of what we deal with now today is cell phone records. And so whenever you've got text messages, if somebody goes through and requests specifically text messages or some sort of communication related to a certain subject, and it's been identified in the request itself, then you may have to go through and to create some sort of screenshots if the text messages were made pursuant to some sort of official business. So I know that's an issue we kind of run into nowadays with cell phones is you may have an employer go through and provide cell phones, and obviously it's hard to go through and potentially keep two devices, a personal device and then a business cell phone. But sometimes it may be a little bit better, at least for these types of purposes, to kind of keep your personal records to yourself, so that way they're not ever kind of potentially at issue with these public records requests. And so that's just kind of a pointer to go through and to keep in mind there. So again, what is a public record? Again, kind of outlining exactly what this is. It's pretty broad and encompassing. And so the three kind of elements you're looking at are these sensitive documents or files or any other type of recordings. And again, each of these documents or files or recordings have to have been made pursuant to law or ordinance or in the connection with the transaction of official business. And they have to have been created by some sort of governmental agency. So what are some examples of these public records? One of the first things you may think of are personnel records. You may go through and have a request for somebody requesting a personnel record for certain employees. And so that is an example of a public record. They may go through and request disciplinary reports as part of that too. And again, depending on the type of request that's made, some different entities may go through and keep different information in personnel records. So it's important to go through and to understand exactly what is specifically being requested. But other examples of personal or public records may include travel or leave information for employees. Again, emails, text messages, voicemails. You don't necessarily think about voicemails, but voicemails can be a public record. And so it's important to keep that in mind. Published financial or performance audits, meeting agendas, minutes, and notes, including drafts. So, these drafts of these different records can go through and be requested as well. Sometimes people may go through and request these in terms of the drafts to see exactly, okay, what was first within these drafts, and then, where did we go from there before we went through and had the official or finalized meeting agenda or anything related to that. So keep that in mind, especially when you are dealing with rough drafts, that these are records that can be requested. And so it's best not to put anything negative in there if you can avoid it, just because, again, these can be requested by citizens. So some of the other examples can include contracts. So if you've got a contract that the city's gone through and enacted or executed with some sort of vendor, somebody may go through and request that to see exactly how much was paid for a service to be provided or for some sort of product that was bought. Citizens have a right to go through and to know this stuff. So if they go through, if they make a records request for a certain thing, they can go through and request those contracts. So it's important to keep that in mind. Other important things to think about are financial statements. So other accounting records can be included with that. And then as you'll see here on the list, this is not necessarily meant to be all encompassing, but just some good examples. You've got citizen communications, budgets, utility bills, traffic citations, recordings. Nowadays, recordings are becoming more and more important, especially when you're dealing with law enforcement. A lot of law enforcement are dealing with body cams, and there are some exceptions to that, but it's just, as a general rule, that is a type of public record. And so if there's an exception that may apply, not all body cam footage is going to go through and be permitted to be provided. But keep in mind, as a general rule, these types of recordings can be a public record that's requested. So in making these requests, there are some different things that have to be thought about, and some requirements to go through and to make sure that these requests are accommodated. So a public records request coordinator is not required to go through and provide, or excuse me, may not require a written request to view a public record, but can require a written request for copies to be made in writing. So if you have somebody that comes into your office requesting a public record just for inspection, they're not required to go through and to make that request in writing. So keep that in mind. However, you can go through and make that a requirement whenever somebody does want to go through and to have some sort of copies. So if they are requesting specific copies, and so obviously there's a little bit of distinction there. But there's not necessarily any cost to go through and to view a public record. There may be charges to go through and obtain copies of these. So, if somebody wants to come in and spend their time pouring through these documents, there's not necessarily a cost to go through and to do that. So just keep that in mind. The request for copies is supposed to be sufficiently detailed so that way the records custodian can identify the specific reports. As you can imagine, it would be hard for a records custodian to go through and to know exactly what somebody may be requesting, or to specifically define the scope of what somebody may be requesting. So that's something we often run into as attorneys, is trying to figure out, all right, what's the scope of a specific request here? And the same thing here, whenever somebody's making a public records request, because a citizen may go through and think that the city may keep, or the county or whoever may keep a certain type of file, however, may not necessarily understand the background and what may all be involved in going through and getting that specific document. So there may be much more involved. There may be much more encompassing. As I alluded to earlier, sometimes if somebody requests a personnel file, somebody may also be requesting some sort of internal investigation that goes in a personnel file. But and depending on whether or not the governmental agency keeps record of that within the personnel file, you can see how that sometimes can be a distinction there. So it's important for those requests to be sufficiently detailed, so that way the custodian knows exactly what to look for. So the custodian can require the requester or shall provide, the requestor, the person requesting the records, of an estimate of reasonable cost for producing these records. So if somebody goes through and says, hey, I want a copy of all contracts from, the city of Springfield from 1960 to 1970, the records custodian is going to have to go through to provide some sort of estimate for the cost of producing those records. Obviously, the more attenuated those requests may be, the higher cost it may be for going through and producing those records themselves. So it's important to go through and provide an estimate of that cost. And again, the estimate may go through and obviously differ, because may be more work involved depending on the specific request and where these records may be stored. It's also important to know the records custodian is not required to create a document that's not already existing. So just because somebody goes through and makes a request thinking that a document may be existing, a recording may be existing, if it's not there, you don't have to produce it. That makes sense. Obviously, if it's not in existence, you can't really go through and create it. So sometimes that can be maybe seen through if somebody wants some sort of overview document of something, and you've got a number of documents that don't necessarily provide some sort of summary. Instead, you've got to go through and provide essentially probably all of those documents that relate to whatever request was made, as opposed to some sort of summary. Or if the summary is specifically requested for certain spending on a certain year or by a certain person, if there's not a document that goes through and provides that specific summary, can't really produce it, obviously. Records custodian may require an appointment to view a public record when there's a reasonable basis for requiring the appointment. So if somebody's going to go through and be spending a lot of time inspecting a specific document or series of documents or whatever other record, and it may be better off to have a specific point in time to have that available and to have it for viewing, then it's permitted to go through and to have an appointment for that. So that's important to keep in mind, just because you may not want somebody hanging out in whatever office for business hours of a specific day. So to go through and to make it for appointment viewing, you can go through and kind of somewhat limit that time, or at least make it more reasonable and available for folks that may need additional time or space constraints to view whatever record's been requested. So what are the requirements for responding to a public records request? The statute provides that there are some different steps here to go through and to respond to different requirements for responding to a records request. As you can imagine, there may be certain things that are easily provided. And so those are going to be, they can be provided within 7 business days. But if they can't necessarily be provided within 7 business days, again, alluding to some sort of more expansive request for a large number of documents, as you can imagine, some of those can't be provided within 7 business days. If you are looking for old records or old receipts or old contracts dating back several decades, that's probably not going to be something that can be easily pulled and provided to folks. So, what's the option for that? So the records custodian is able to go through and provide that they may need additional time to produce whatever record that's been requested. So generally, whenever a records request is made, again, you can go through and provide access to the record, assuming all the requirements have been met. You can go through and provide a denial in writing for the access to those records with a legal basis for the denial. Can't go through and just say, I don't like this person. There needs to be some sort of legal basis for the denial itself. Or again, provide in writing that additional time is necessary to produce whatever record has been requested. So it's important to note that the custodian's failure to respond to a request in one of the above mentioned ways, either the access to the records, the denial for the legal basis, or that additional time is necessary. If you don't provide that within 7 business days, that in and of itself constitutes a denial, can be actionable by the citizen under Tennessee Code Annotated 10.7.505. So what do you have to provide? Again, a lot of this stuff is in the statute. And again, it's a little bit hard to parse through sometimes. But one of the first places, if you do have questions, maybe to potentially either go to the statute or go to the Open Records Council's website. They provide a lot of good information. And so that should be one of the good places to start, because it's going to go through and kind of walk you through what may be provided as a record or the number of exceptions to the records request. Back whenever the Public Records Act was enacted, there were not as many exceptions as there are today. Over the years, there have been a lot more exceptions to the public records request. And so it's important to go through and kind of know what those are. And there's a link here that's on the page. And whenever this is sent out, I think that the PowerPoint should go through and provide a good resource or starting point for some of the general basic information. And so this link, or you can go through and access it through the comptroller's website. They provide a lot of good information in terms of what the exceptions are, and other kind of baseline information. So be sure to go through to keep that information in mind. So as mentioned on this slide, there are hundreds of exceptions to the Public Records Request Act. And so many of those are found in the statute itself. But as I mentioned, the Open Records Council provides a good overview and a little bit more easier way to digest a lot of these exceptions. And so there's a spreadsheet that goes through and identifies certain exceptions based on the specific governmental entity that may have been requested of the record, that may be holding the record itself. And so different governmental entities may have different exceptions. So depending on where the records request is made from, whether it's some sort of state department or municipality or a county, there may be different exceptions that apply. And so I thought it may be helpful to go through some of these exceptions, just because from an overview or broad perspective, it's good to know exactly, all right, what are some of these exceptions? As you can imagine, it's probably not best to go through and to have, as a general matter, every record open to inspection, just for either safety purposes or for other general equitable purposes. So one of the things that are accepted from the public records request are medical records. So if somebody has medical records within a medical personnel file for an employee, those are typically accepted under the Public Records Act. So if somebody comes in requesting that information, you may be able to go through and provide a denial and cite to the specific statute that provides for the exception to the Public Records Act. Some of the other exceptions can include throwing out an example. If you've got somebody that comes in and requests potentially more nefarious public records, they may go through and request, all right, I want the passwords to every employee's computer. That's obviously going to be accepted under the Public Records Act. That's not going to be something that's going to be in line with what the Public Records Act was enacted for. There are obviously safety purposes for going through and having an exception to either passwords or passcodes or some sort of security plans. So those are all general things that can be accepted to if somebody comes in and requests that information. Those can be denied based on those exceptions. Going through some of the other exceptions, as I mentioned, some of them may not be applicable depending on what organization you may be a part of, but it may be good to go through and kind of at least have a general idea in terms of what these exceptions may be, depending on whatever entity may be. Some of the things that may also be accepted to can include, some sort of competitive proposal as part of a bidding process. So while the bidding process is still ongoing, those typically are not going to be required to be provided until the contract has been awarded or some sort of closure to that process has been made. So throughout whatever competitive process, those may not be able to be provided until later on. So that's an exception to keep in mind. One other thing to think in mind in terms of a possible exception and is any type of privileged communication. So say if you've got a county or a department or a city, and the city attorney has gone through and made some sort of privileged communication, say about some sort of internal investigation or an ongoing case in litigation, those privileged documents are going to be exceptions to the public records request. So to the extent somebody comes in requesting information about those, the requested entity is not necessarily required to go through and provide those. And so again, it's a good point to make sure that you're aware that any type of privileged communication is not necessarily required to be provided. One other thing to think about in terms of exceptions, any type of criminal history background check, that's an exception. I found that kind of interesting. Sometimes people will go through and have criminal background checks before coming on for employment. And so that is one exception. If somebody comes in and requests, again, as part of a personnel file, they may go through and request, so-and-so Mike Smith's personnel file. And if Mike Smith had a criminal background check before coming on to work for whatever entity, that's going to be an exception. And so that can be withheld from any type of public records production. In the same line, drug testing is also something that is an exception to the Public Records Act. So to the extent anybody requests anything related to employee drug tests, that's also going to typically be accepted, an exception. One other thing to point out is also some sort of proprietary information. So again, if there is some sort of proprietary information regarding a business that may have contracted with some sort of entity, then that's going to be an exception to the public records request as well. And I think I alluded to this earlier. One of the exceptions also relates to body cam footage dealing with minors. So if you have a records request for body cam footage of an officer conducting an investigation within a school, and there are minors that are visible on this footage, then that's going to be permitted to be accepted under the statute. So again, there are a number of different exceptions. It's typically good to go through and to look specifically, as specific as you can, to see exactly whether or not these exceptions would apply. And especially if you're making a denial based on these exceptions, you're going to want to make sure that it does indeed apply. And so either looking at the statute or information from Open Records Council, that may be helpful in making that determination whether or not the exception does apply. So as you can imagine, sometimes there may be specific information that should be confidential. And so within a records request, if again, I keep referring to personnel files, it's kind of a more general, easily identifiable example. But as you can imagine, within a personnel file, there may be confidential information within that. And so even though a personnel file may have confidential information, to the extent you can go through to redact that, then you can still go through and provide that record so long as it's redacted. And so whenever you are going through and making a redaction, Generally, that may be done by photocopying whatever record. You're not going to typically provide the original record, and it's actually recommended not to provide the original record. So if you are making those copies for inspection, be sure to go through and make the copy and then redact whatever specific confidential information there may be. And so keeping that in mind, so the question may be, all right, what confidential information should be redacted? Social security numbers are good starting point. That's information that's obviously confidential. Typically driver's license numbers, tax ID numbers, those are all information that can be redacted. Other information may relate more towards employee personal information. So if they have a copy of a canceled check for direct deposit purposes, sometimes that may be within an employee's file. Be sure to go through and have that redacted, so that way that confidential information is not provided. Depending on if the record is provided digitally, then it's important to go through and redact that information in whatever program you're using, and make sure that the metadata is not necessarily readily available to be viewed. Sometimes you can go through, and if you're using either Adobe or some other similar program, sometimes that metadata is not necessarily fully redacted and it can be pulled. So if you are providing whatever files digitally, make sure that the redactions are done to go through and to make sure that that metadata is removed, so that confidential information is not necessarily provided. So again, alluding to dash cams, body cams, photographs, one important exception to the Public Records Act is deceased images are not public records. So you may have accident footage or photographs, and there may be photos of a deceased person. So it may require either redaction or depending on the file itself or the photograph itself, it may be a complete exception to the Public Records Act, to where it doesn't necessarily, it may be permitted to be denied if somebody's gone through and made that request. That being said, there's always an exception to the exceptions here. And so if an estate's gone through and made a request for a deceased individual, they may go through and waive that confidentiality. They may say that, we are waiving that as part of our request. And so at that point in time, whatever photograph or file or footage may be provided without the redaction. So again, kind of coming back to the original statute we looked at, who can access these governmental records under the Public Records Act? And again, the Public Records Act grants access to public records to any citizen of Tennessee. So this is part of the analysis whenever you are conducting, the custodian may be conducting for providing these records. You need to figure out, is this person a citizen that's making a request? If somebody is a citizen of another state and they've come to your organization or entity and requested something, you need to make sure that they are, again, a citizen of Tennessee. Records custodian has the right to deny or inspect from a non-citizen. So if you've got a Kentucky citizen that comes across the border and wants to go to, say, a town right across the border, they may work there or whatever. If they don't live there, if they're not a citizen, then it can be denied. And again, you're able to go through and define what proofs of citizenship may be in your public records rules. You may want to go through and make sure that you do have these public records rules or protocols for when somebody does go through and make these requests. So that way you can go through and have kind of a checklist to follow to make sure exactly. And you can go through and show that you're not necessarily picking and choosing what policies to apply. It goes through and makes sure that there's a baseline for providing responses. So that way you're not ended up being hauled in court and having two different responses to two different people for the same thing, and maybe having some issues there. So it's important to keep that in mind. As noted on this slide, in Tennessee, citizen does include a convicted felon. So if you have somebody who may be incarcerated, they may go through and make a public records request. They are considered a citizen, so keep that in mind. So here's an example from the rules and regulations for proof of citizenship. Proof of citizenship can be provided by a valid Tennessee's driver's license or other state issued photo ID. So at the time that the records request is made, the records custodian can go through and request to see that individual's driver's license or other photo ID. But there may be also other ways to go through to demonstrate that that somebody may be a citizen, say they don't have a driver's license or other photo ID. Depending on your specific rules that you may have set up, it may be valid to go through and have some other means of proving that that individual may be a citizen. So again, when and where can these public records be accessed? Again, I kind of touched on this earlier, but a citizen has the right to request both the inspection and copies of public records during normal business hours. One of the specific statutes provides that a governmental entity is not supposed to go through and delegate its responsibility to a private entity. You can't really go through and outsource these issues. And so you can't really go through and avoid your obligations as a public entity by outsourcing this to a private entity. All right, so again, referring back to the Open Records Council's website, they provide a lot of good information. And so I would go through and definitely use that as a potential starting point, that or the specific statutes, if you got access to those. Those can be good starting points for any records request that may be made to make sure that there's not any exception that may apply. Again, the model public records policy is something that can be utilized by whatever entity you may be a part of, and they've got a good overview of a possible policy. If you don't have one for your specific organization, I would definitely go through and potentially recommend taking a look at this to possibly implement it on behalf of either your city or your department or your county, just to make sure, just because again, they provide kind of the model policy here. So that way you can go through and look at it. So it provides an overview of what to look for in terms of those requesting it, and then also in terms of the response that should be made. It also provides some forms for also in terms of when a records request may be made. Again, the written request form is not necessarily required to be made, so I can make an oral request for public records, but even still, it may be good if somebody's requesting copies to go through and have to go through and to cite some of these forms, or at least to have a form that's somewhat similar to these policies that Open Records Council has gone through and made in terms of the model. It's a good baseline. If you want to go through and provide, maybe some more generous access to these records, you're not necessarily prohibited from doing so. However, if you decide to make things more restrictive, that may be troublesome. It could run afoul of the Public Records Act. So in sense of, again, accountability and openness and the public policy that surrounds that, again, these Open Records Council's model policy, they provide a good baseline. And so that's a good starting point. And like I said, if you want to make it a little bit more generous or more open, you're more than welcome to do so, but to make it more restrictive could potentially run afoul of the Public Records Act. So also on this website, again, referring back to it, you can find a scheduled reasonable charges for those individuals who are wanting to go through to make copies for their own review. Obviously, if somebody's going through and requesting thousands and thousands of pages, the organization or entity that has the records is able to go through and receive some sort of reimbursement for that. And so there's a schedule of reasonable charges that's listed on there. I believe these reasonable charges were made maybe back a few years ago. I don't know how much inflation has affected copy prices. I'm not Michael Scott working for Dunder Mifflin, so I can't go through and provide those specifics for you. However, back in, I think, 2016, 2017, you had a price permissible charge of 15 cents per page for black and white copies, and then 50 cents per page for color copies. So if you've got somebody going through and making a request for hundreds of pages of documents, and those documents may go through and be if they're black and white, then you're going to charge them $15, and that's going to be permissible. Again, the charges, I would go through and try and keep it to what's requested in terms of the model policy, the schedule of reasonable charges, because that will go through and make sure that you are in compliance there with that safe harbor policy. As long as you are going through and kind of following the model policy or the schedule of reasonable charges, there's typically going to be some sort of safe harbor in case you do kind of run into hot water with a legal issue related to these things. So it's important to kind of stay as close to those model policies as you can. Because again, say if your organization goes through and instead tries to charge $15 a page, that's not necessarily going to be considered reasonable. And so the citizen may potentially bring some sort of action related to that. One other point to make regarding the copies, the entity or organization that has the records, they can go through and charge for labor, and that charge for labor can typically be made after an hour's worth of labor. And then it's usually going to be made at the hourly rate of whatever employee may be going through and fielding that request or attempting to provide the documentation. And so again, there's going to be a reasonableness standard. If the employee that's providing the document, if they get paid at say $15 an hour, and if they perform 2 or 3 hours worth of work, typically that first hour is going to be free of charge. However, the second and third hour that the employee spent trying to go through and provide those records or producing the copies of the records, then they're going to be, the city or other entities going to be able to charge the labor for that. So again, using $15 charge, if you've got an employee who is making $15 an hour and they spend 2 or 3 hours worth of work, after you subtract the first hour of work, you could be potentially looking at either $15 or $30 on top of what other copy charges may be made. So that is permissible. Again, I would refer to the schedule of reasonable charges. They are listed on the Open Records website, Open Records Council. That's a good, again, starting point and a good way to kind of look at these requests. Yeah, again, on the labor and other charges related to copying, they're going to be presumed to be reasonable as long as they're consistent with those scheduled reasonable charges. So again, another reason why you should go through and kind of be using that as a good starting point for the specific records request that's been made. So a pointer here in terms of the best practice guidelines. I'm sure, as you can imagine, these requests can potentially sometimes be used and abused, unfortunately, by certain citizens. You may have a certain citizen that comes in once a week and wants thousands and thousands of pages. So it's important to go through and to balance the need to function efficiently, also the need to balance the protection of confidential information, and also maintain the integrity of these records whenever somebody's gone through and requested them. So it's important to go through and kind of keep that in mind. And so if there is, some sort of legal action that is that's taken, it's important to go through and kind of keep that in mind. So if there is an easily produced request for a certain record, say it's all right, I want a receipt from October 22nd, 2021 from John Smith when he went through and had a company lunch. That's going to be fairly easily produced, I would think, and so shouldn't necessarily be charged much for providing that unless there's some sort of extenuating circumstances. But again, depending on the specific record that's been requested or records that have been requested, the volume of those records may go through and dictate a higher charge, or obviously if they're stored in a certain area, say they're stored in the basement of City Hall in an area that nobody goes to anymore and they haven't been scanned, it may be a little bit harder to produce. So the reasonable amount of time to go through and to produce whatever records have been requested, that's going to be permissible. So as long as you can make an argument that those are reasonable, you should be covered there under the safe harbor practices. So again, kind of alluding to what I said earlier in terms of a citizen has the ability to potentially go through and to file some sort of action if their request's been denied, and it's not necessarily if they feel like it's not for permissible reasons. So Tennessee Code Annotated 10-7505 addresses the ability of a citizen to petition the court. If their request has been denied, they can go through and file that in either Chancery, Circuit, or any other court in the county having equity jurisdiction. So for like local government records, the petition's usually going to be filed in the county where those records have been either requested or the records are located. And so if the request is denied and the petition is filed, the records custodian must prove by preponderance of the evidence that there is provision within the state law that authorizes the non-disclosure of the record. So say a citizen does go through and file a petition with the court to receive these records, then the records custodian is going to have to go through and respond and say, all right, here's why we did not provide this. It was confidential based on attorney-client privilege, or it was an exception under this specific statute, or we confer with Open Records Council, and Open Records Council went through and indicated that this is an exception under this specific statute. And so again, that's going to be based on a preponderance of the evidence. And what that means is essentially 51%. If the records custodian can go through and show that by 51%, there's a provision, 51% of the evidence, that there is a provision within the state law that authorizes non-disclosure, then the court or fact finder will be able to go through and find in favor of the records custodian. So one important thing to note is that if the court finds that the governmental entity willfully refused to provide the records, then the court has the discretion to assess attorney's fees. And so that's typically one of the issues that the governmental entity may use in terms of motivation for making sure that the records request is responded to appropriately, is that they don't want to go through and be responsible for attorney's fees. As you can imagine, the reasonable attorney's fees can go through and add up, and obviously potentially would go through and outweigh whatever cost the initial record may be to produce. So again, kind of referring to if somebody's going through and requested something pretty simple in terms of like a one-page document, a contract, or something that's easily produced. Again, if there's not an exception to it, then there's not going to be really much cost to go through and produce it. And if there is a willful refusal to provide that document, I'm sure, as you can imagine, the attorney's fees for that would heavily outweigh the initial production of that document. So that kind of serves as a motivating mechanism for the governmental entity to go through and to make sure that they are in compliance with, in good faith. So again, that willful refusal, that's a pretty high standard. As long as you are complying in good faith, as long as you can go through and point to an exception or to some sort of reason as to why a denial was made, it's likely a court's going to go through and decide there's not some sort of willful refusal. Again, as long as even if the governmental entity was in error, if they can make a good faith reason or a good faith effort to say exactly why the record was denied, then a court's not necessarily going to go through and award attorney's fees. So, as noted here, willful does not necessarily mean negligence or bad judgment. Again, somebody can be wrong about something. They can potentially be negligent, or again, using bad judgment and deciding whether to deny a record that maybe should have been provided. But that's not necessarily going to go through and rise to the level of willful if a court's looking at this, where a citizen's gone through and brought a complaint under these circumstances. So again, willful means bad faith. Essentially, you are kind of singling out this person who's made a request to say, all right, we're going to deny this because I don't like this person. And I don't have any other reason as to deny it other than the fact that I don't like Mike Smith or Jenny Jones here who's making this request. So it's important to go through and to keep that in mind. Some important contacts. So Elisha Hodge is a good point of contact. She's within TAS, and so she may be a good person to go through and to touch base with if you do have questions on these public records issues. I believe she went through and she had worked with in the Office of Open Records Counsel. Otherwise, you can actually go through and reach out to those at the Office of Open Records Counsel as well. And so one thing to point out in terms of the last slide, in an effort to go through and to kind of show your good faith in terms of with compliance with the Public Records Act, it may be a good point to show that you did reach out to Open Records Counsel. Say you've got something that's questionable as to whether or not a record that should be provided or produced, or if there's a specific exception. By showing that you reached out to Open Records Counsel, that can be a good faith step for going through and showing exactly that you did comply in good faith with the statute, that you did go through and take the steps with compliance in mind. Another good point maybe to reach out to your city attorney or to your county attorney or to whatever counsel may be in your entity. Have them go through and see if they can take a look. If there is a question about a statute, they may be able to look at some case law to see exactly what applies, what doesn't apply. So those are steps to go through and to take recommended steps to make sure that there is some sort of good faith compliance with Open Records Act, Public Records Act. So the Public Records Act, it's important to note, is not the only way for citizens to obtain these documents. So typically before litigation, the way I see it, I'll kind of preface this by saying I practice a lot in litigation, and I often get brought in when lawsuits have been filed. And so sometimes these public records requests are often a precursor to a citizen filing suit. They want to go through and gather as much information as possible. And so it's important to understand that if somebody does come in and if there is an expectation that they may be potentially looking to file suit, if you are in a specific governmental entity, it may be good to pass that information along, or to at least kind of keep track of people that are making those requests, just because it can be a precursor to somebody who may be seeking to litigate a claim. That being said, when somebody does litigate a claim, say they file suit on a separate issue, say they don't necessarily file suit pursuant to the Public Records Act, say they file suit pursuant to a wrongful termination claim. Through the courts, through the wrongful termination lawsuit, the citizen may go through and be able to obtain documents either through a subpoena or through a discovery request. And there's going to be different requirements there for producing those documents. So that being said, the Public Records Act is only one avenue of which a citizen can go through and obtain these documents. Subpoenas, or like I said, discovery request, can provide other avenues for citizens to obtain these documents. And again, that typically requires suit to be filed. And so again, when suit's filed, typically notice is given. The governmental entity, if they have been named in the suit, they're going to be provided with a summons and complaint. And it's good point of practice to go through and to give heads up to whoever may be the litigation counsel defending the claim, to have an idea that these specific records requests may have been made. I know it always makes my job a little bit easier if I'm defending a city or a county or other entity, when a records custodian gives me a heads up that that John Q. Citizen's gone through and made this request, and he's already sued the city or the county or whatever other entity, or if there's an expectation that he will file suit, again, based on some sort of potential wrongful termination claim. Having an idea of what records requests have been made and what records have been provided gives me an idea exactly what the individual may have and how they may be viewing a certain claim. So again, it's always good to kind of tip off litigation counsel as far as when these requests have been made, if there is an expectation of litigation. So we've got maybe 4 or 5 minutes remaining, and I know with these specific public records issues, there may be questions. And so we'll go through and field those to the best we can. And if we're not able to get to them all, we'll try and provide either a response or maybe a point of contact for providing that information down the road.
We do hope that you've all enjoyed the webinar. Our next scheduled webinars are for January 25th and February 22nd. So if you haven't registered for those yet, we'll have Sarah Curtis with our loss control team presenting engaging employees through performance management, and John Grubbs with MTAS in February presenting professional and proven hiring practices. We'll leave everything on for a few more minutes as we wrap up. If any of the questions come in through the chat, or if anybody wants to talk afterwards, we can also share contact information. But we really appreciate your time today, Ryan, and we appreciate each of our members' time for joining us to learn more about open records.
Yeah, thank you.
We've got a quiet bunch today, no questions coming in.
Well, that's understandable. And again, feel free to reach out either through the chat box, or you can always reach out to me or to anyone at Open Records Council. Those are good kind of points of contact. Or again, the council for your specific entity may be a good starting point as well. They may have a better, well-versed knowledge about the specific records that may have been requested, or specific working knowledge about what it may take to get those records. So each of them may have that requisite baseline knowledge to provide a more detailed response.
And Ryan, we can share these slides with the participants. Is that correct?
Yes, exactly. So again, these slides are kind of a good starting point. It's always good to go through and to kind of at least use this as a first stop before going through and making some sort of difficult decision. You may not want to go through and rely just on these slides. You may want to go through and look at the specifics of it. But as mentioned, yeah, it's a good starting point, and the links on these slides are a good way to start.
Well, so far, our only question was about the slides. So feel free, each of the participants, to kind of drop off as we're finished. But if you have any other questions, we'll give it about 2 more minutes, and then we'll go ahead and close out the webinar.
Yeah.
Ryan, I think we can go ahead and close it out because there's only 10 participants left. So thank you again for your time.
Yeah, no problem.
We appreciate it.
Thank you.